persons having business before this court shall draw near and give their attention, and they shall be heard. God save the United States and this honorable court. You may be seated.
We will hear argument in number 75, 1862, Dr. Victor Marshall, petitioner, against the Commonwealth of Massachusetts, respondent. Is counsel ready?
Yes, sir.
Mr. Schechter.
May it please the court. My name is Roger Schechter, and along with my co-counsel, Mr. Michael Lampert, we represent the petitioner in this action, Dr. Victor Marshall. This case is before the court on a writ of certiorari to the Supreme Judicial Court of Massachusetts, which affirmed Dr. Marshall's manslaughter conviction by a jury in Suffolk County Superior Court. Jurisdiction is based on Title 28 of the U.S. Code, Section 1257. This court granted certiorari to consider two questions. First, whether the application of the state manslaughter statute to a physician who causes the death of a fetus during an otherwise lawful abortion would constitute a denial of due process, and second, whether such an application would unconstitutionally burden the rights articulated by this court in its opinion in Roe against Wade. I will deal with the first of those questions, and Mr. Lampert will deal with the second. Before turning to the due process claims, however, I would like to sketch briefly for the court the factual background of the case. The case arose when an unmarried 17-year-old woman, who has been referred to throughout the proceedings as Alice Roe in order to protect her anonymity, sought an abortion at Suffolk County Hospital in Boston in September of 1973. She was examined at that time by a Dr. Curter, and on Dr. Curter's instructions, she was admitted to Suffolk County Hospital on September 30th, 1973. After her admission, she was examined again by the defendant, who decided that it would be best to attempt an abortion by a procedure known as saline infusion. Alice Roe gave her consent to that procedure, but when it was tried, the doctor, Dr. Marshall, and another doctor who assisted him were only able to draw blood and therefore determined that it would be unsafe to proceed with the saline infusion. They then decided upon a hysterotomy in the best health interests of the mother and obtained the mother's consent for that procedure. Dr. Marshall performed that hysterotomy in Suffolk County Hospital on October 3rd, 1973. Sharply conflicting testimony was offered at the trial as to what happened during that operation. According to the version accepted by the Supreme Judicial Court of Massachusetts as being most favorable to the prosecution, Dr. Marshall, after he introduced his hand into the uterus of the mother, detached the placenta which connected the fetus to the wall of the uterus, and then held the fetus in the uterus for a period of approximately 3 minutes while he was watching the clock on the operating room wall. The SJC also stated that the fetus took some gasps of air while Dr. Marshall was in the process of removing it from the uterus. No one has contended, however, and no one has stated that the fetus has ever taken any breaths at any point after it was fully expelled from the mother's uterus. After 29 days of testimony, the jury returned a guilty verdict, and the Supreme Judicial Court affirmed that verdict. Throughout the proceedings below, defendant has preserved all his constitutional objections, which he now presses upon this court. Dr. Marshall raises two independent due process claims with respect to his conviction, either one of which we feel is sufficient to call for a reversal of the conviction. Those are, first, that the opinion below constituted a retroactive redefinition of the crime of manslaughter so as to make criminal conduct which was legal when performed, thus denying the defendant of due process, and second, that the Massachusetts manslaughter law was so vague and imprecise as to make its applicability to cases of this type a violation of due process as well. I'd like to turn first to the retroactivity concept. Now, this court declared in 1964 in its decision in Buoy against the City of Columbia that retroactive judicial expansions of criminal statutes and criminal acts would constitute a denial of due process. Thus, if Dr. Marshall's acts were legal on October 3, 1973, the subsequent labeling of them as illegal, as manslaughter, by the court below constituted an expansion of the law, an attempt to catch Dr. Marshall in a newly drawn net which would naturally violate the Due Process Clause. To ascertain whether this indeed happened, we must examine the Massachusetts manslaughter law on the date of the operation. Now, Massachusetts, in the area of manslaughter, has opted for a common law definition of the crime. Massachusetts has also opted, in its state constitution, for the common law of England to become its binding rules of decision. Thus, when Massachusetts became a state in the United States, it inherited the law of England, and that law would continue to control unless Massachusetts changed it. Now, as we point out in brief, the law of England was the law as articulated by Lord Hale. Precisely, that rule says that where there is an initial battery upon a fetus wholly within the uterus of the mother, even if the fetus is born, fully expelled from the uterus, lives for a period of days, and then dies from the prenatal injury, that there can be no manslaughter.
Mr. Schechter, in the Buoy case, this court was concerned, was it not, with a statute which was plain on its face, which we found that the state court, the highest court in South Carolina, had manipulated. Now, I'm not so sure, therefore, that Buoy is as applicable to this case, which deals with a common law situation, as you claim.
Well, Your Honor, I think that if we were left with nothing but Buoy, that might be a problem. But Buoy has generated a progeny of cases which show that its principle is really universally applicable. For instance, the Buoy Doctrine has been used in the area of obscenity cases. We specifically cite the Sherpicks and Jacobs cases in brief to prohibit retroactive expansions of the law. The Buoy Doctrine has been used in cases where federal statutes which seem to precisely encompass conduct were nevertheless considered too imprecise to warrant applying them to a specific defendant. That's the INSCO situation. Basically, there really is only one case in which Buoy was held not applicable to a redefinition of crimes, and that's the Almeida case, which respondents discuss at length in their brief. Now, as we point out in our reply brief, the Almeida case is truly unique. Felony murder is a situation where the state has said in advance to a criminal defendant, if you violate our written law on kidnapping or rape or armed robbery, you hereby have notice that you are potentially liable for any death that results in the course of the commission of that act. Now, just because a bystander had never been killed by another bystander in Pennsylvania before does not mean that the defendant in that case didn't have notice that the felony murder rule would be expanded to cover him. And that's the only instance, Your Honor, where an expansion was held not to violate Buoy. So we would argue this evening that the Buoy Doctrine would indeed have force in this area.
You know, Mr. Schechter, you've got to be very careful in interpreting the Buoy case. You know, one of our judges was the counsel in that case, Judge Motley.
Well, these sudden judicial elevations often leave us caught by surprise.
Mr. Schechter, before you get on with Buoy, don't you have to establish first that your version of the common law was the common law of Massachusetts at the time of this trial?
Well, Your Honor, as we argue in brief, we think that under any view of the common law, there was an expansion here. Now, we think that the correct view is the Hale view, and we think we demonstrate that adequately by relying on an authority which this court approved expressly in Roe against Wade. We adopt the analysis that Professor Means uses, and this court thought that that analysis was precisely right. But even if this court were to assume that respondents are correct in contending that Lord Cook's contrary view had been adopted, we would not think that that should give this court any trouble, because indeed there was a departure from that view as well.
I've had difficulty, Mr. Schechter, in understanding why you believe it makes such a vast difference, morally or philosophically, whether the fetus was in the uterus or ex utero. If the facts are, as you concede they were, and that is that the doctor suffocated the fetus, then what difference does it really make if he detached the placenta from the wall, as a result of which the fetus died of suffocation, whether it was in the fetus or out of the fetus?
Well, I'm glad Your Honor raises the question of morality.
I'm here to make you
I think that that's precisely an area in which this court has to be very alert to falling into principles which would violate established constitutional doctrine. You and I might agree that what the doctor did was morally reprehensible. On the other hand, we might disagree. I might feel, for instance, that a fetus is undeserving of the protection of the laws. Precisely because men may disagree as to what point a fetus deserves the protection of manslaughter law, somebody has to specify. And the state of Massachusetts, by sitting by and silently letting people in the Commonwealth assume that Hale continued to be the law, was informing people that they didn't think this thing was worthy of protection under the manslaughter laws. And maybe they want to change that view, and that's fine. I mean, I might go up to Beacon Hill and lobby to change that view. But we are stuck with that view, and Dr. Marshall was trapped when that view was changed. So we think, Your Honor, that there was indeed a retroactive expansion in this case that should call for a reversal.
Aren't we really stuck with a finding which the jury apparently made here, that the doctor did hold the fetus in the uterus for 3 minutes? Didn't the jury apparently so find that that was what he did?
Well, I think that that's right. I think that this court does have to take that as a fact. But as I attempted to explain to Justice Kaufman, I believe that that fact alone has no legal significance absent a statement one way or the other as to whether or not that fetus was an object of solicitude of the law. It's quite possible that I could take an axe and chop up this podium. Now, unless there was a law proscribing me from doing so, I would think that my act would not be criminally culpable.
Well, in Buoy, wasn't it a major criterion in deciding fair warning arguments whether the conduct at issue was improper or immoral? And isn't this a classic case of that here?
Well,
did we note that in Buoy?
Well, Your Honor would certainly be aware of the facts in Buoy, but as I recall the case...
I had to reread it to find out that I argued it.
Well, as I recall the case, the court assumed that the morality or immorality of the conduct by the persons involved in that situation was irrelevant. It certainly was the case that at least some of them testified that they assumed they would in fact be arrested. They assumed they'd be arrested for disturbing the peace rather than for trespassing. But nevertheless, they were operating under assumptions that they were violating certain moral and perhaps different legal rules. When they were then trapped by an expansion of the legal rule of trespass, the court distinctly held that that was a violation of their due process rights. And I really think, Your Honor, that even to the extent that the retroactivity situation in this case is not entirely clear, and that to the extent that the case is not on all fours with Buoy, the vagueness problem compounds the situation greatly. And I would, if with the court's permission, like to turn to those vagueness problems at this point. Now, this court has always had a lot of trouble with vague statutes for a number of reasons. It's always assumed that the vague law fails to give a defendant notice, and that that violates due process. It's always assumed that the vague law fails to give guidance to persons charged with administering the law, prosecutors and jurors and judges and, in the ultimate sense, voters. And it's also the case that vague laws violate a kind of fundamental societal dogma that we have, that the law ought be explicit, just for the sake of making sure that persons in authority can't violate a loosely drawn statute. Now, this law was indeed...
Mr. Schechter?
Yes, Your Honor.
Is it your understanding that the vagueness doctrine applies to a common law situation to the same extent and in the same manner as it applies to a statute?
Well, I think there are matters of degree, Your Honor. I think that the use of a statutory term, which is very, very vague and refers out to sort of concepts which are basically semantic, terms like treats contemptuously, is not much different than using a term like person and cross-referencing the term person out to a body of common law, which is just as vague as the words treats contemptuously.
Do you have any cases that support your position in this respect?
Well, I can't say that I have any cases that precisely support the position, Your Honor, but I think that, for instance, cases like the Mcpoyle case, cases like the Pierce case, are somewhat analogous. For instance, in those cases, for instance, taking Mcpoyle, it was declared by federal statute that to transport a motor vehicle across state lines, knowing it to be stolen, that would be a crime. And then the term motor vehicle was left undefined. Now, presumably, as cases were decided, they developed a body of law as to what could or could not be a motor vehicle. Then along came Mr. Mcpoyle, and he transported a stolen airplane. And this court said that that wasn't a motor vehicle. Or at least if it was a motor vehicle, he had no notice that it would be considered a motor vehicle. And we think that the situation in this case is quite analogous.
Well,
because
isn't it true that the common law, by its very nature, requires the prosecution of marginal offenses in cases of first impression? Isn't that true, the common law, just by its very nature?
Well, I would attempt to sort out, as I think we did in our reply brief, two distinct areas in which the law operates, and I think that what Your Honor has pointed out is definitely true in one of those areas, but we question its applicability to the other. Where new patterns of conduct are brought before a court, the court obviously is going to have to react to them. The court can't sit idly by and say, we have never had a case on all fours with this one, so the defendant goes free. That's because the state has already said, for the purposes of measuring your conduct, you have noticed that we are going to use a standard of reasonableness. And if you want to knock on your neighbor's doors and ascertain the societal view of reasonableness, perhaps you ought to do that. But at least you have noticed that that's what we're going to do. And with physicians, we make it even easier. We tell a physician, we're going to hold you to the standards of your profession. There is a second area, however, in which first impression cases are much more difficult. That's an area in which all of a sudden the law is expanded to cover a new object, a new thing which the law has never protected before, as it was in this case, as it was expanded to cover a fetus in utero.
Was there ever a prosecution for manslaughter of a fetus?
Not in Massachusetts that we can discover, Your Honor.
Was there ever a prosecution for assault and battery of a fetus?
That I'm unsure of. Don't recall seeing any, but I couldn't represent to the court that they don't exist.
Wholly apart from the abortion statute itself, let me phrase the question this way. Were these cases always dealt with in the Commonwealth of Massachusetts by resorting to the abortion statute?
Well, Your Honor, after that statute was enacted, I think that that's a fair statement. The abortion statute was used to reach cases in which there was any sort of attempt to terminate a pregnancy, any sort of attempt to terminate the existence of a fetus. Now, before the statute was passed...
And even a viable fetus?
I would assume so, Your Honor, yes.
Doesn't this court's decision in the United States against Veitch go a long way to overcome your vagueness argument? Because there, the court held that a doctor was not being held to too vague a standard when prohibited from performing abortions unnecessary for the protection of a mother's life and health.
Well, that's right, Your Honor, but I think that fits very nicely into what I said before. So thank you. The word health cross-references out to standards of what a doctor ought to know based on his professional ethics and his professional training and standards which are set up by the profession. So when you say to a doctor, your standard of conduct is ascertained by whether or not the abortion should be performed in the mother's health interest, he can go out and he can check his medical books and he can find out what he can and can't do. That's not vague. But there is no reason why the medical profession is peculiarly equipped to tell the legal profession and to tell society as a whole what objects do and don't deserve the protection of the manslaughter law. That's a tough moral question. And we think that if the state wants to decide one way or the other, The legislature ought to do it. And if they don't want the legislature to do it, well, then by God, let the courts do it in prospective, forward-looking dicta, and let Dr. Marshall go home, because he had no notice. And we think that that basically is the defect in the conviction below.
Mr. Schechter, this may not be a fair question, but if you assume that you're correct and that Lord Hale's view of the law was the law of Massachusetts at the time, and that somebody had read that law, that statement of Lord Hale, to Dr. Marshall, do you think he would have done anything differently from what he in fact did?
Oh, if someone had read Hale to Dr. Marshall,
yeah.
I think he would have said, well, fine, now you've reassured me that my conduct is in fact legal.
Well, suppose they'd read Cook.
Well, once again, Your Honor, I think that his assumption would have been, and this is an area of conjecture, but I think his assumption would have been, okay, at least I can order my conduct at this point. I know that if the child suffers from an injury which I give to it during the abortion process, and then it's born alive and dies, that I'm going to be held liable, and maybe I better not perform the abortion. On the other hand, he might say to himself, well, okay, so long as the child were to die before it was fully expelled from the womb, I would be immune from criminal liability. And since that would be usually the case in an abortion of a fetus of gestational age that we have here, I think he might have decided that he was in an area where he was protected from criminal liability. But
conceivably, that would have persuaded him to keep his hand in the womb for 3 minutes.
Well, Your Honor, I think that's one good reason why this court ought to assume that the Cook view wasn't adopted. I think there's an inherent contradiction in that view. It seems to say that if I assault a pregnant woman and I hit her once, and then she miscarries with a live child who dies, that I'm liable for manslaughter. But if I'm careful and I hit her 5 times, I'm not liable for manslaughter because the child will be stillborn. And that rule is so irrational that we think the Hale view was a fortiori the law of Massachusetts.
The trial judge in charging the jury spoke of a fetus in the process of being born. You recall that?
That's right, Your Honor.
Is that anywhere in Lord Cook's rule, or was that imported?
Well, what Lord Cook says is that if a child be born alive and then die. Now, Cook does not go on to explain what born alive means. But every state that has adopted Cook's view, with precious few exceptions, has gone on to say that that means total expulsion from the womb, absolute full separation from the mother. Now, in this case, the charge obviously permitted a finding that life signs during partial expulsion would be...
Well, what worries me about this case is what apparently worries my brother, and that is that if Lord Cook's view is as you say it is, then it would certainly give the doctor a motive to prevent the birth of the child, and simply keep the child there, or go ahead with the with the saline solution injection, even though it wasn't indicated, and thus avoid any possible prosecution.
Well, I think that's a problem, Your Honor, but I think it's a problem that my brothers have to worry about.
How could the state ever deal with that properly?
The state ought to legislatively change the law when it discovers the defect.
What would you suggest the state say? How could they change the law?
Well, we point out in brief, Your Honor, I believe it's footnote 8 in the main brief, an example of a Texas statute which was clear, precise, and sharply defined a crime of killing an unborn child. And we think that if Massachusetts is concerned about these objects and as a politically responsible device wants to protect them, then they ought to enact a statute that's similar to the Texas statute. And that seems to me to be an efficient way to resolve the problem and to avoid any kind of due process violation at the same time. Now, it is often the case that in our system of law, we occasionally let a guilty man go home, guilty in the moral sense, because to convict him would violate some fundamental notion of fairness that's implicit in the system. I mean, I think that that may be very well what decisions like Miranda and that line of cases are about. And I think that in this situation, you have something of the same problem. The state may have had a defect in its law, but it's not in accordance with any kind of reasoned constitutional principles to allow the state to remedy the defect by surprising a defendant. The final point, which I think makes all of this even worse, is that it would have been very easy to be precise here. In Smith v. Godwin, which involved a flag contempt statute, the phrase treats contemptuously was held to be vague, and the state was told, go back and try it again. Be precise. Now, that's a much tougher case to be precise in than the case we have here. It's much tougher to specify what conduct you wish to punish as contempt of the flag. But the court made the state go and do it again, the same state, the state of Massachusetts. We think that what the court ought to do in this instance is to send Massachusetts back, tell them to let Dr. Marshall go, and tell them to do it the right way this time. And I'd like to yield back my minute and thank the court for its attention.
Thank you. Mr. Lambert, I think you have 30 minutes. Mr. Lambert, before you commence, I take it your position is that Lord Hale's view was the common law of Massachusetts. You also take the position, as I understand it, that Lord Cook's view, even if that should be deemed to have been the common law of Massachusetts, would justify reversal of the conviction of your client.
That's correct, Your Honor. On the basis...
On the theory that Lord Cook stated that the child must be born alive.
Or at least that all those jurisdictions which have interpreted Lord Cook's view have interpreted born alive to mean
Right.
fully
Now,
expelled.
are you going to develop an argument further on that point, or
Not unless Your Honor has a question, which I would be pleased to try and answer.
what will you address primarily?
I will primarily address the second argument in our brief.
Doe v. Wade?
Roe v. Wade, that's correct.
All right, will you carry on? I may come back to this.
Fair enough. Barring questions from the Chief Justice, I will principally address myself to the argument that the rule of law here applied unconstitutionally burdens the mother's right to an abortion, which right this court recognized in Roe against Wade. We suggest that there were two separate and independent defects with the jury charge in this case that cause it to unconstitutionally burden that right. The first defect was the judge charged the jury to determine whether the fetus was viable in fact, to borrow phraseology from the administrative law area, to substitute its judgments for that of the doctor about the viability of the fetus. It is our contention that the doctor's reasonable medical judgment must govern and that the jury should be precluded from entering into a de novo determination of the viability of the fetus. Our second main contention is that the jury should be precluded from considering any evidence which was not available to the doctor prior to the operation, and that they should be limited to that information which he had prior to the onset of his operating on the mother in this case. We believe that the rules adopted by the Commonwealth of Massachusetts in the jury charge, which is affirmed by the Supreme Judicial Court, will deter both doctors and mothers, and will deter mothers directly and indirectly. Physicians will be, the first thing we would point out to the court is that the line of viability is, in any event, a somewhat difficult line to determine. I think both briefs are in accord on this point. Viability is not an empirically observable fact. One has to look at other pieces of evidence to determine whether a fetus is or is not viable. The most common piece of evidence that's used is gestational age. But as the evidence in this case clearly points out, and it is customary, there is a great deal of dissension about the determination of gestational age.
Well, now, couldn't you get us back to this case? It would be very helpful. The judge charged the jury on this point, didn't he?
Yes, he did, Your Honor.
And what did he say? Didn't he say that the jury would have to find that the fetus had drawn a breath?
Yes, Your Honor, but that's not the charge with regard to viability. He didn't say that the jury would have to find that the fetus had drawn a breath. There are two parts of his charge. One part of his charge was that one would have to find that the fetus was alive. And he suggested in that part that the drawing of a breath was evidence of being alive. But he then went on to say, recognizing the serious interplay between the law of manslaughter and the right to abortion, that it would be meaningless to convict someone who took a fetus that was alive but was bound to die anyhow and expedited its death, that is, a fetus that was not viable. And so he required the jury to find both points. He required them to find viability in fact and born or in the process of being born.
Let me ask you, Mr. Schechter, what would your, maybe this is an unfair question too, but what would your answer to be to a case where the doctor had the fetus in his hand and the fetus was fully born and had drawn a breath, and he put his hand over the mouth of the baby and suffocated the baby? Would you say that's manslaughter?
Is the fetus viable or non-viable, Your Honor?
It's breathing.
Well, I think that the trial judge recognized, as this court recognized in Roe against Wade, and as was set out in the evidence at this trial, that there are fetuses that are alive but not viable. There are fetuses that will, it is medically determinable, that they will live in a hospital for 19 hours.
Well, then what are you suggesting? Are you suggesting that this should become a battle of doctors and doctors' opinions before a lay jury in order to determine when a fetus is viable?
No, exactly the contrary, Your Honor. What we are suggesting is that the standard of review should be whether the doctor who was doing the operation made a reasonable medical determination. That is, we shouldn't have doctors coming in and saying, well, I think it was viable, I don't think it was viable. The question rather is, a doctor at the time, would he reasonably have thought that the fetus was non-viable?
All right, now, Mr. Lampert, let's take your case then. He believes the fetus is non-viable, but it's breathing.
Well, it's not clear that it breathed, but assuming that it did.
I'm asking you to assume so. It is breathing. I agree here, there's a question about it. But it is breathing. May the doctor be prosecuted for manslaughter if he puts his hand over that child's mouth? And
not in our opinion, Your Honor, because the mother, before she went into the operation, expected to have an abortion. And what she expected from an abortion, and what we think this court meant to give her a right to in Roe against Wade, was coming out of the general anesthesia for the hysterotomy and not finding that she was possessed of a child.
But can you fairly derive your chilling effects argument from Roe against Wade? Doesn't that decision make the point that at the point of viability, the rights of the fetus may counterbalance or perhaps outweigh the rights of the mother?
No,
in
Your
other
Honor.
words, can we really pursue that chilling effects line of reasoning if in some cases it is bound to trespass on the rights of the fetus?
No, Your Honor, I think that Roe is somewhat more careful about its wording of the mother's right. I think that Roe says that at the point of viability, the state develops a compelling state interest in the potentiality of life. Roe was careful not to give the fetus a right to life. Rather, it gave the state a compelling state interest in the potentiality of life. We think that difference is significant because a state cannot be chilled from the exercise of its power in the same way that individuals can be chilled from the exercise of their fundamental rights, in our opinion. So we don't think that Roe gave the fetus at viability right. The other demonstration of that, Your Honor, is Roe specifically provides that where the mother's life or health are endangered, that even a viable fetus may be aborted.
oh, but that cuts the other way too. We haven't got a question here as to whether the mother's life or health was involved. Now, isn't there inherent in what you just said the feeling of this court as expressed in Roe against Wade that, true, you think about the mother's health first, but the fetus has an independent right not to have the doctor act wantonly and recklessly.
Well, I think first, Your Honor, that it's important to point out here one of the enigmas of Roe, which is that for the abortion to occur in any trimester, the doctor and the mother must decide that it is in the mother's health interest. In the third trimester, the doctor must determine that it would endanger the mother's health or life. It's not clear what difference in quantum of determination that the doctor must make at those varying points, and we think at most it would be a difference of degree and not of kind. So in this case, certainly the doctor had made the right kind of determination to allow him to abort a fetus.
I didn't see any evidence that was presented to us in the record on appeal indicating that the jury considered at all, or that you submitted to the jury any question concerning the mother's health or life.
Well, Your Honor, that we did not introduce extensive evidence, but there was no contest by the Commonwealth, at least to the minimal level of the mother's health, that would have justified the abortion in the first instance. In any event, we believe that there would be a chill on women who would have, in fact, non-viable fetuses if the state can exercise its manslaughter law right up to the line of viability in fact. It's our position that the fetuses which this court intended to protect in Roe can still be protected, but because people will be chilled by the operation of the criminal law, that the criminal law's line should stand back from the constitutional line so that the people who are chilled will fall exactly on the viability line. Now, we can't guarantee this court that that result will follow as the night the day, but we suggest that's a better approximation than the approximation the Commonwealth in this case adopted.
Because I'm less at home in Roe against Wade than I am in Buoy. Because when I came along, we didn't have any right to abortion. I had to, go ahead and have that baby, and now he's here at Harvard Law School.
I'm sure, Your Honor, that is because he got the kind of care...
What else can I tell you?
I'm sure, Your Honor, that's because he got the kind of care which an unwanted child would not get.
Well, that leads me to ask you what rights, if any, the fetus has, in your view. You kind of slipped over that, I think. Does fetus have any rights which the state can protect, and if so, how does it go about protecting them?
Well, Your Honor, it's our belief that Roe was very carefully worded on this point, and that the fetus is not possessed of any rights, that the state is possessed of authority to act largely on a theory of protection of the fetus, but that the power rests in the state and is not a right vested in a particular fetus. For example, we would say that a particular fetus would not have a right to a guardian ad litem because the fetus was dissatisfied in a legal sense with the Commonwealth's law as it protected the fetus.
The word person in the Constitution, and it appears in many sections of the Constitution, has never been construed in a constitutional sense to include a fetus, has it?
That's correct, Your Honor. The Roe decision points that out at great length. And that is among the reasons we think that Roe does not ascribe rights to the fetus. Coming back to the chilling effect for a moment, we believe that the physicians who thought that they could be Monday morning quarterbacked in a subsequent trial by jury de novo determination of viability would either cease to perform abortions or would bring into the operating room expensive equipment which would make the cost of abortions go much higher than they presently are. We think the net effect of that would be to deny some women with, in fact, non-viable fetuses their Roe-granted right to an abortion. It's our suggestion that by moving the Commonwealth's line back, that chilling will encumber fewer, in fact, non-viable mothers with, in fact, fewer non-viable fetuses. Additionally, we believe that women will be deterred because of the jury's determination or the jury's ability to hear evidence which the doctor could not have available before he began the operation. The Roe right to an abortion is a woman's right in consultation with her physician. In certain types of abortive procedures, such as here, hysterotomy, the woman must be given general anesthesia for the operational procedure to occur. She certainly is not in a position to make an intelligent choice about what to do with the fetus while she's under general anesthesia. She, therefore, needs to know with some fair certainty before she undergoes the general anesthesia whether she is going to wind up with a child or whether she's going to have the abortion which she expected. And women who are close to the line of viability but have, in fact, non-viable fetuses may decide, knowing if the Commonwealth's position is sustained, knowing that they may wind up with a child, they may be chilled away from having abortions for a variety of reasons. First, very prematurely born children tend to have a greater number of birth defects than children carried to term. Secondly, she's going to have to pay the cost of very expensive intensive care for that child for quite some time, because the cost of neonatal care for a very premature child is exceedingly expensive. And she's going to have to bring up a child that she never wanted. And the Roe decision, as we've pointed out in brief, points out that the unwanted child situation is beneficial in the end neither for the child nor for the parents.
Is it not a fact that the major burden would fall upon the poor and the mentally defective and people in that category, because they usually wait until the last trimester before moving, whereas the intelligent and people who are in better financial straits usually move early?
That's usually true, Your Honor, though we would point out as well that there are certain medical tests which cannot be done until the 16th or the 20th week for determinations of deformity in the fetus. And even people who are well off and well educated may not be in a position to make an informed decision about what to do until those data become available. But as to the first group, certainly we believe they're important, Your Honor, and they have generally been a source of, or they have been an object of solicitude of this court.
Then there, your argument would be there's a real chilling effect, because doctors would shy away in those cases from performing an abortion because of the fear of risk.
That's exactly right, and a woman would be denied the right to an abortion, which Roe seems to have given her.
Mr. Lambert, yes. Before you carry on, you are bound, of course, by the jury finding that the fetus was viable. Your position, as I understand it, is that do you think the trial court misinstructed the jury? Would you outline the sort of instruction you think would have been appropriate?
Yes, Your Honor. I think that instead of, well, first, I think that there were two ways the trial court could have remedied what happened here. I think one is a charge and one is a particular evidentiary ruling, which I'll address myself to in a minute. As to the charge, instead of charging the jury to determine whether, in their opinion, the fetus was viable, he should have charged the jury to determine whether the doctor at the time prior to the operation, there's two components again, reasonably on the facts then available to him, determined that the fetus was non-viable. And if he had used that kind of charge, and I'm sorry I can't word it more precisely, I would be inclined to look actually at charges or opinions in the administrative law area to look at the wording.
That really isn't helpful, because then, once again, you're letting the jury pass on that, quote, viability.
Well, but now we're talking about a new kind of viability, Your Honor. We're talking about the physician's determination. And to be sure, some physicians will be chilled even by this new concern. As Judge Dooling points out in Doe against the Nassau County Medical Center, there is always the danger of the person in the operating room looking over the physician's shoulder who says, I'm going to get that guy, and decides not to say anything during the course of the operation. But it's our belief that the chilling effect would at least be minimized by that kind of jury instruction. And
couldn't you think of framing some kind of a charge where you'd have a definition of viability that the jury could understand in terms of weeks, let us say, gestational period?
Well, Your Honor, that's an interesting question. It may be that this court...
You give me an interesting answer.
I hope so, Your Honor. It may be that this court ought to reconsider the notion of viability, or indeed that this court has considered it, and that there is only one district court that has correctly understood this court. As you know, in the Hodgson case, the district court there held that this court's description of 24 and 28 weeks for viability was not mere dictum, but that 24 weeks was a minimal viability age that a state could not reach a fetus younger than 24 weeks. That may be what this court had intended to be interpreted out of the Roe decision. If that's clear, if that's correct, as we point out in the footnote, then the charge here is clearly defective for failure to mention the 24 weeks. If, on the other hand, well, let me go back to where I was going to go. The evidentiary ruling that I was going to talk about in response to Justice Powell's question was, in particular, we point out the use of the weights of the fetal organs. Now, it is clear that a doctor, before an abortion, can't weigh the organs in the fetus which he's about to operate on to determine from the fetal weight, the organ weight averages, whether the fetus is or is not viable. And we suggest that evidence is so prejudicial that one might distinguish 3 times. One might distinguish prior to the operation, during the course of the operation, and after the operation. It's clear that kind of evidence only becomes available long after the mother is sewed up and back on her feet.
Well, is there any test, is there any way that a doctor would know whether a fetus is viable other than gestational period at the time he's performing his surgery?
There are certain other tests which are no more precise than gestational age is. There are certain kind of ultrasound procedures, I believe. You're pushing the limits of my medical knowledge, frankly. I think there are other kinds of devices, but it is my impression that they are relatively new and that they have relatively the same margin of error as gestational age, and that at least for the time being, even the prosecution's witnesses agreed that the generally accepted medical practice to determine viability is to attempt to determine gestational age by taking a measurement on the mother. One last point I should like to make in closing is the discussion of the application of chilling effect in this area. As we point out in our reply brief, this court has not restricted its solicitude for constitutional rights solely to the First Amendment area. It has applied them in the Fourth and Fifth and Sixth Amendment areas as well. And indeed, if the word chilling is magic, then I must apologize to the court, because in a citation of United States against Jackson, the sentence after the one which we quote in our brief, which is at page 33, the sentence after the one we quote reads, "If the provision had no other effect or purpose than to chill the assertion of constitutional rights by penalizing those who choose to exercise them, then it would be patently unconstitutional." They're talking about the right to a jury trial. And so this court, if the word chill is magic, has used that magic word in areas other than the First Amendment. If Justice Powell doesn't want to question me about Mr. Schechter's leftover question, I would yield the balance of my time to rebuttal.
All right. Mr. Bowen.
Thank you, Your Honor. May it please the Court. My name is Michael Bowen. I and my colleague, Mr. Lee, will be speaking this evening on behalf of the respondent to this action, the Commonwealth of Massachusetts. Mr. Lee and I hope, with the Court's permission, to make 2 arguments. I will argue, against the perspective of vagueness and retroactivity challenges, that Massachusetts' interpretation of the common law of manslaughter, forming the basis for petitioner's conviction in this case, accorded fully with the fundamental fairness required by the Due Process Clause to the 14th Amendment. Mr. Lee will argue that the common law of manslaughter is entirely consistent with this Court's recognition in Roe v. Wade of a woman's right to seek and obtain an abortion. Before proceeding further, I would, if the Court please, make one observation which I feel is central to an understanding of the Commonwealth's position as a whole, and that is this. Dr. Victor Marshall, the petitioner in this action, was indicted, tried, and convicted for committing manslaughter, not for performing an abortion. He was convicted of manslaughter because the jury found that he inserted his hand into the maternal uterus, separated the placenta from the uterine wall, thus cutting off the supply of oxygen to the fetus, and then, instead of removing the fetus immediately, waited for an interval of at least 3 minutes while the mother bled and the baby choked before he removed it, and because the baby, after the process of removal had begun, then breathed and later died.
Mr. Bowen, why hadn't the Commonwealth of Massachusetts ever prosecuted anyone else before for manslaughter involving the fetus, a viable fetus?
Your Honor, there is no indication in any of the record that was made available at trial or in the briefs which petitioner has filed that the fact situation currently at bar had ever arisen before.
Do you know of any manslaughter? Were you aware of any manslaughter prosecution?
And the Commonwealth of Massachusetts has never before prosecuted a manslaughter arising out of the out of the death of an infant born alive as a result of a hysterotomy abortion.
Why not?
As I'm I do not know the reason, Your Honor. I can speculate as to the reason, however.
Could it be because the abortion laws were ample to cover?
Your Honor, the reasonable expectation would be that any crime which occurred in this context before this Court's decision in Roe v. Wade would have been under the abortion laws, and it would not have been necessary for the Commonwealth, in order to reach that conduct, in order to protect newborn life, to implement manslaughter prosecutions.
Let me ask you one more question along this line, Mr. Bowen.
Yes, Your Honor.
Why wasn't this doctor indicted for murder?
Your Honor, because the Commonwealth's position was that it could not establish malice.
You had an intention to kill here. That was your allegation. In effect, your proof established that.
Your Honor, our allegation
Looking
and
at the clock for 3 minutes and waiting until life expired?
our allegation and intent was that this was reckless and wanton misconduct, Your Honor.
Well, those are words. I'm thinking of the political considerations and the power that's given to the prosecutor to elect what crime he's going to choose and just who is going to be prosecuted.
Your Honor, that is a legitimate concern. There are a great many factors which might bear upon a prosecutor's decision about what charge to bring. One of those factors would certainly be what he thought he could convince the jury he could convict the defendant of. I would suggest to Your Honor that it is not by any means clear from a review of the evidence that if an indictment had been brought for murder, that indictment could have been pressed to a conviction. I would suggest further to Your Honor that to the extent Petitioner wishes to make a claim that there was an abuse of prosecutorial discretion in this case, that is, for example, to the extent Petitioner wishes to argue that there have been other fact situations such as this which have arisen, which have not given rise to prosecutions, or that there were fact situations such as the present one at the time when Massachusetts abortion prohibition was in effect, which did not give rise to manslaughter prosecutions. Those are factual questions, factual allegations, which Petitioner can properly raise and can properly put to the test of adversary combat by bringing a habeas petition. However, for this Court to proceed upon the assumption that those are the facts animating the present prosecution would be to engage in speculation that is entirely untested by the tools available to the adversary process. I would emphasize to the Court one particular element of the conviction which occurred in this case. That was set out by the trial judge in his instructions to the jury, which is provided at page 22 of the joint record and appendix, to which I invite the Court's attention at this time. Toward the bottom of page 22, the trial judge instructed the jury as follows: I now charge you that if the particular act or omission which causes the death of another was committed by a licensed physician as part of the medically accepted procedures for abortion, then such act or omission is lawful and no offense of manslaughter has occurred. I suggest to the Court then, as the trial judge's instructions made clear, in order to impose criminal liability upon the petitioner in this action, the Commonwealth had to establish that he had caused the death of a human being, that he had caused it by performing wanton and reckless acts.
That's what bothers me, Mr. Bowen. Now, that charge would appear to be a negligence charge. He says if a licensed physician would have done exactly what was done on this occasion, then, of course, there's no commission of an offense. Now, by adding the words wanton and reckless, I submit that a prosecutor can wantonly and recklessly use language to make a civil case a criminal case.
Your Honor, it is important to understand that the trial judge's careful instruction to the jury was not a statement of the element of the offense. The trial judge instructed the jury also that in addition to finding that the acts were not part of any medically recognized abortion procedure, the jury also had to find that the acts were wanton and reckless over and above that finding. The statement by the trial judge to the jury that the acts engaged in, the wanton and reckless conduct, had in addition to be outside of any medically recognized abortion procedure was in deference to this Court's decision in Roe v. Wade. That is, the Court was simply telling the jury if what the doctor did, whether it was wanton and reckless by your lights or not, was part of any medically recognized abortion procedure, then you cannot convict for manslaughter because the Supreme Court of the United States has spoken and its word is the law. In short, Your Honor, the allegations which I have set out, that the death of a human being had been caused by wanton and reckless conduct that is not part of any recognized abortion procedure, was what the Commonwealth set out to prove. It was what the trial judge instructed the jury the Commonwealth had to prove, and it was what the jury found the Commonwealth did prove beyond a reasonable doubt. Petitioner has not challenged the sufficiency of the evidence supporting the jury's conclusion in either of his briefs or an oral presentation this evening. This premise in mind, I would If the court please proceed to the retroactivity question.
Let me ask you something about the charge which you just read to us. If there were no Massachusetts abortion statutes at this juncture, what
Yes,
was
Your Honor.
this charge predicated upon?
The judge's instruction to the jury, Your Honor?
Yes, what you just read.
The judge's instructions to the jury recognized that this court in Roe v. Wade had established a right of a woman to seek and obtain an abortion. And the judge interpreted Roe v. Wade as providing that conduct which would give rise to a prosecution under some other statute, apart from any abortion statute, which was nevertheless part of a medically recognized abortion procedure, could not, because of this court's decision in Roe v. Wade, give rise to that prosecution. The judge, in other words, was instructing the jury that if what occurred was only a lawful abortion, if everything that was done was in aid of a lawful abortion, then no manslaughter offense could be found, even if the other elements of a manslaughter offense were made out. In short, the purpose of the charge was to save, solicitously to save, the rights recognized by this court in Roe v. Wade. On the question of retroactivity, if the court please.
Mr. Bowen.
Yes, Your Honor.
I assume that as a predicate to your argument, you're going to address what seems to me to be a fundamental issue in this case, and that is what was the law of Massachusetts at the time of this act? That's fundamentally your case, before you get to whether or not that's retroactive.
Your Honor, I must differ with the court. What was the law of Massachusetts in this case is not before this court. This court recognized in Murdoch v. Memphis that what the Supreme Judicial Court of Massachusetts, or what the Supreme Court, the highest authority in a state, says is the law of that state, is the law of that state.
Even if their holding violates the Constitution of the United States?
Your Honor, if what the state's highest court says is the law of that state violates the Constitution, then the conclusion is that the state's law violates the Constitution, not that it's not the law of the state.
Well, then we don't have to accept it if it violates the Constitution.
Excuse me, Your Honor?
I say we don't have to accept it if it violates the Constitution.
Certainly not, Your Honor. I'm not suggesting that what the Supreme Judicial Court of Massachusetts said was the law in Massachusetts is binding on this court as being constitutional. I'm only saying that what the SJC said was the law in Massachusetts. And whether the views of Sir Matthew Hale or the views of Lord Cook or the views of Professor Means are in this court's view the more correct statement of the English common law in the 14th century is not determinative of the action which is before the court.
But the question, what is the law of Massachusetts, before you get to the retroactivity argument, goes to the issue of vagueness in the court's definition of what the law was, doesn't it?
It certainly does.
In that context, the question is asked, what is the law of Massachusetts, or was, according to what Massachusetts' highest court said it was?
I think that is exactly right, Justice Motley. The Commonwealth in this case must defend the law of Massachusetts as the law was defined by the Supreme Judicial Court. The question is not whether the jurisprudence which preceded the interpretation of this case determined what the law was. The question gave rise or determined that what the SJC said was the law. The question is whether the course of the law previously in Massachusetts and in other common law jurisdictions was sufficient to meet the constitutional requisites of adequate constitutional notice. That is the issue which is addressed by the various questions of which interpretation was sounder or which interpretation had a sufficient basis. In short, what is before the court, to state it affirmatively, is whether what the SJC said was the law and what therefore was the law in Massachusetts was sufficiently supported by prior jurisprudence, by prior judicial expressions to satisfy the Constitution's notice requirement. What is not before the court is whether what the SJC said was the law in Massachusetts. That in mind, Your Honor, and I would emphasize that the Commonwealth has argued vigorously and extensively in its briefs that the recognition of the live birth murder rule and the recognition of the rule of partial expulsion, in recognizing those rules, the Commonwealth's courts did not extend the common law, but rather applied it as it had been most authoritatively articulated by courts and jurisdictions upon which it was entirely proper for the courts of Massachusetts to draw in attempting to determine the content of a generic common law offense.
Are you talking about the Chavez case in California?
The Chavez case, Your Honor, established the rule of partial expulsion. It was later accepted in the Singleton case.
Was that established for Massachusetts?
The court in California and the court in Alabama are courts upon which Massachusetts is free to draw in determining the content of its own common law, Your Honor.
Excuse me.
The Chavez case was decided, as I recall, in 1947.
Yes, Your Honor.
And you mentioned an Alabama case. Are there any other cases in the United States that apply what you characterize as a partial expulsion doctrine?
I have not found any, Your Honor.
And didn't the California court in Chavez state expressly that the prevailing common law in the United States in 1940 was to the 1947 was to the contrary?
It did indeed, Your Honor.
And so you think a citizen of Massachusetts, in that state of the law, where the California court on which you rely states that the prevailing common law is different from what it declared, a Massachusetts citizen in those circumstances is entitled to know what the law here is?
Your Honor, a citizen of Massachusetts who examined Massachusetts law in an attempt to discover what the state of the law was would have found that Massachusetts freely adverted to interpretations of the law in other states and did not blindly accept what had been stated 3.5 decades before to be the prevailing view as the prevailing view in Massachusetts. He would have found further, Your Honor, that Massachusetts courts recognized the fundamental principle recognized in the common law, that when the reason for a rule ceases, the rule itself ceases, and that a citizen who had examined the law of Massachusetts would have been justified certainly in reaching the conclusion that the most contemporary view of the common law and the view which most accorded with medical and scientific reality would possibly be one which the Massachusetts courts would embrace. I would emphasize to the court that, and here we really are, I would suggest, in the retroactivity area, because the question we are addressing is whether there was sufficient basis to provide notice to a citizen of what the interpretation of the law in Massachusetts would be. In its landmark decision in Buoy against City of Columbia, this court established the principle that there are due process limits on the extent to which an interpretation which does expand the law can be applied to conduct which precedes the interpretation. I would suggest with all respect, however, that in making that observation we state the question and not the answer, for it remains to determine what test can be applied by judges who are grappling with a case of first impression in a particular jurisdiction, and a test which will not at the same time paralyze the common law, foreclosing it from adaptation and advance. I would suggest further that if we do apply what the court expressly said in Buoy, that is, the test being whether the interpretation is, in the court's words, indefensible and unforeseeable by reference to the law previously expressed, we find that that plainly is not this case. The recognition of Lord Cook's authority and the possibility that Massachusetts would advert to other interpretations contemporaneously stating the law would not have been an indefensible view. Only last... Yes, Your Honor.
Would you concede that the law was, at the very least, ambiguous?
Yes, Your Honor. The law was certainly ambiguous. That is to say, a person examining the law could have said would almost certainly have said there are two possible interpretations which could be made.
And I believe you would also concede that there are limitations to the court's power to extend the common law.
There most certainly are, Your Honor.
Aren't there areas, particularly ambiguous areas, where it would be better for us to hold that it is wiser to extend the law by statute rather than by common law?
That only last term in Mullaney against Wilbur, this court recognized that what Buoy requires by way of constitutional notice is that the previous expressions of the law be sufficient to inform potential defendants, and once again I use the court's words, of the possible criminality of their conduct. That is, ambiguity is not enough. The question is whether one, looking at the state of the law, could have been aware that what he was contemplating doing was possibly criminal. That is what the court said in Mullaney against Wilbur. And despite the radical distinction between Buoy and the present case, a distinction which entirely favors the Commonwealth in this situation, which the court pointed out in questioning my brothers for the petitioner, the fact remains that even if we apply the words in Buoy uncritically to the facts of the present case, we conclude, I would suggest, that there is no basis in Buoy for a retroactivity challenge here. I would suggest further to the Court, and I would urge most vigorously, that we are not left without guidance in attempting to apply the Buoy principle to the facts of the present case, that is, to a problem of interpreting a generic common law offense in a case of first impression. The Third Circuit, in the United States ex rel Almeida versus Rundle, has addressed that precise problem and has addressed it authoritatively and comprehensively. In Rundle,
Well, in Rundle, we were dealing with felony murder, which of course is sui generis by its very nature. That is, you never have notice of the scope of the felony murder, do you? And how is manslaughter in that same category?
Your Honor, that is what Petitioner says at pages 3 and 4 of his reply brief, that felony murder is sui generis. The authority which he cites does not say that felony murder is sui generis. It simply points out that one who perpetrates an underlying felony thereby may, without constitutional objection, be held without further notice to risk criminal liability for any homicide that occurs therein no matter how tangentially that homicide is related to the felony itself. I would suggest to the Court that this argument which Petitioner urges emphasizes the similarity between felony murder and manslaughter rather than any distinction that might be made between them. I would suggest that by reasoning precisely analogous to Petitioner's in the felony murder context, one who engages in wanton and reckless conduct can, without constitutional objection, be held without any further notice to risk criminal liability for any homicide which results from that wanton and reckless conduct.
Now let me ask you. This doctor had injected through the abdomen into the uterus a saline, tried to withdraw a fluid and inject the saline solution.
Yes, Your Honor.
Tried it 3 times.
Yes, Your Honor.
And then he called an expert, as I recall the testimony. Someone else tried it.
Yes, Your Honor.
Now, if this doctor had gone ahead and he was successful in injecting a saline solution, this child, this fetus, had been stillborn, ejected from the womb.
Yes, Your Honor.
There wouldn't have been any manslaughter charge, would there?
Certainly not, Your Honor.
Well, now, it seems to me, it's very hard for me to get it into my head that by this super technicality of extending the definition of a person to include one who's in the process of being born, and that, in the saline solution case, that fetus is in the process of being born because it's ejected after the saline solution. That by simply extending that, then you have a manslaughter case and a conviction if the process used by the doctor is hysterotomy instead of saline injection.
I would differ with Your Honor, Justice Kaufman. The thing which made this case manslaughter and not abortion was not the fact that it was performed by hysterotomy. It was the fact that the doctor, as the jury found, performed wanton, reckless acts which were not part of any abortion procedure.
I understand that. We're using language. Let's look to the acts. The needle could have done that very act instead of the doctor's hand.
Yes, Your Honor.
And in the first case, it wouldn't be manslaughter.
Your Honor, in the second case, it wouldn't be manslaughter either, so long as it was part of any medically recognized abortion procedure. Petitioner himself testified under oath, Your Honor, that he realized that what the jury ultimately found he did was not part of any medically recognized abortion procedure, was inconsistent with the health interests of the mother, and would probably kill the fetus. Petitioner also testified under oath that he was aware that abortions do, on occasion, result in live births, and he testified further that as chief resident at Suffolk County Hospital, he had made provisions, he had established procedures to provide for what would happen when an abortion resulted in a live birth. In short, what makes this case manslaughter and not simply abortion is not that an act occurred which killed a fetus, but that an act occurred which was outside of any medically recognized abortion procedure, and therefore clearly not protected by this Court's decision in Roe v. Wade.
Would it be outside of the medically protected procedures to inject the saline solution when the doctor's withdrawing blood instead of water?
If the doctor had proceeded with the saline infusion, Your Honor, after drawing blood, I think that after drawing blood 3 times, when the expert concluded that it would have been medically unsound.
What would happen? You wouldn't have a manslaughter case, would you? Because that uterus hadn't been opened and the fetus wasn't in the process of being born, and yet the same end had been achieved.
Your Honor?
So you're going to induce the doctors to perform not medically approved procedures for purpose of bringing about an abortion.
Your Honor, I must differ. If a saline infusion had been attempted after it had been determined by experts, as it was in this case, that that attempt was not the proper abortion procedure and was inconsistent with the health interests of the mother,
Yes.
and that saline infusion should result in the death of a baby alive which died as a result of the saline infusion, that would give rise to a prosecution for manslaughter just as the instant case did. What is critical is not the method that is used per se, not the method of abortion which is used, but whether the method, whatever it is outside, or whether what is done is outside of any medically acceptable abortion procedure.
All right, if that's so, if this is a manslaughter case, as you say,
Yes, Your Honor.
dependent upon whether the doctor used any recognized medical procedures, how are these 19th century Massachusetts cases on abortion relevant to this discussion?
The Massachusetts cases on abortion, Your Honor, established to anyone, to one who had reviewed Massachusetts law, that the Commonwealth had accepted Lord Cook's view as an authoritative statement of what the common law was and what the common law therefore was in Massachusetts. They are relevant to providing someone with notice that he had better advert to Lord Cook's view in evaluating the possible criminality of his conduct. I would argue further, Your Honor, that that Petitioner does not dispute that if the Rundle test, and I would review the Rundle test briefly here, that being that an interpretation which does extend the law may nevertheless be applied to the case before the interpreting court, that is, to adopt Petitioner's language, may be applied retroactively if it meets two conditions. The first being that it does not contradict the specific formulation in the jurisdiction previously announced, and the second being that it conforms with the fundamental policies of the common law. I do not understand Petitioner to dispute the proposition that if the Rundle test is applied, then there is no constitutional objection to be found here. Petitioner attempts to diminish the authority of the Rundle case by turning to cases which have interpreted statutes. For example, he suggests, without elaborate explanation, that the case that United States Ex rel. Clark versus Anderson in the Third Circuit is inconsistent with the holding in Rundle. I would suggest to the court that that case, involving as it did an attempt to impose criminal liability for embezzlement, an exclusively statutory crime, the Petitioner's urging of that case is answered by the Anderson court itself. It took pains to point out at page 1081 of its opinion that Delaware long ago recognized that embezzlement is not a crime at common law. Hence, in that case, there was no common law foundation for any possible criminal liability. The only conceivable statutory basis had disappeared when the statute was declared unconstitutional, and I am unable to see entirely what inconsistency there is between a holding that attempting to establish criminal liability in that situation is constitutionally objectionable and the Rundle holding.
Well, Mr. Bowen,
Yes, sir.
don't you suppose it would be reasonable for us to hold that a long and continuous history of non-enforcement of the law, and I'm referring to the manslaughter statutes here, is the equivalent of a holding to the contrary?
Your Honor, the court the decision which Petitioner relies on extensively, the Insco case, in that decision, the Fifth Circuit found that it was not enough, simply that there had been a long history of non-prosecution of the offense charged. The court found that in addition to that, there had to be demonstrated in order to find on Buoy grounds that a prosecution was unconstitutionally retroactive, that every presidential candidate who had conducted a campaign since the campaign reform law had been passed had violated it in the same way that the defendant before the court had violated it. And the court in Insco then said, this unique concatenation of circumstances, unlikely ever to be repeated, is what is required to establish, and not failure of prosecution alone, is what is required to establish that there is a retroactivity challenge on a Buoy basis.
Mr. Bowen?
Yes, Your Honor.
May I return a moment to your vagueness argument? I pose this hypothetical.
Yes, sir.
You rely on Cook. Let's assume that the Massachusetts legislature had enacted the Cook rule into a statute.
Yes, Your Honor.
And from your brief, it would read something like this. If the child be born alive and dieth of the battery, this is murder, For in law, it is accounted a reasonable creature when it is born alive.
Yes, Your Honor.
That's your statute.
Yes, Your Honor.
Now, if you were the prosecuting attorney drawing the indictment in this case, you would follow the statute.
Yes, Your
You'd
Honor.
have to. So the charge would be a battery on a fetus resulting in it not being born alive.
Excuse me, Your Honor?
You would charge the jury in terms of the statute, using the statutory term, born alive. You'd have to.
Oh, yes, Your Honor, certainly.
Right. Now, in fact, the trial judge in this case, as I understand it, added a gloss to the term born alive and really read it to mean in process of being born alive. Do you think there'd be a fatal variance between the indictment based on the statute and the instruction given by the court in this case?
I do not think so, Your Honor, for the reason that the court has to tell the jury what the term born alive means, where that might be in controversy. It is not clear that born alive means completely separated from the uterus. Indeed, it is notable that every case petitioner cites holding that complete separation is required to establish live birth within Lord Cook's meaning came after 1780, the date at which Massachusetts accepted the common law. I would argue further to the court that an answer to its question was provided by the expert testimony of Dr. Ruth K. Benson, an expert gynecologist who had performed over 2,000 abortions. Dr. Benson testified to the court below that, yes, the fetus at any stage of pregnancy, when the uterus is incised and the placenta is detached, that fetus is in the process of being born. Dr. Campbell, another expert witness, testified for the prosecution that after the placenta had been detached, what had occurred was live birth. In short, Your Honor, the instruction the trial judge gave to the jury, if objectionable on any grounds.
Why is that live birth after the placenta is detached? Why isn't that dead birth?
It is live birth because what is then the baby, the infant, is still alive, Your Honor. It is still gasping, trying to breathe, and will continue to do so for an interval.
How do you know that?
That is what the expert witness, Dr. Campbell, testified to the trial judge, Your Honor, and that is also corroborated by the fact that in this case, the baby managed to breathe after the process of extraction had begun.
That testimony was very equivocal, as I read it. Very equivocal.
It was indeed equivocal, Your Honor, but the jury found on its basis that the baby nevertheless had breathed outside the womb. And as has been pointed out numerous times, that finding is binding upon this court. It has not been challenged by petitioner.
You mean now that you want the jury to determine this? Again, I asked that question, I think, of your opponents. The jury should make a determination based upon which doctor they have greater faith and credit in, and if he appears like Marcus Welby, then of course he's going to carry the day. Is that it?
Your Honor, in the United States of America, we have committed the awful question of whether a man or woman is guilty or innocent of a crime to the judgment of a jury. The judgments will necessarily be imprecise, but that does not mean that a reviewing court, I suggest, should sit as a super jury. My time has elapsed, and I thank the court for its attention.
Sure.
Mr. Lee, you may proceed.
Thank you, Your Honor. May it please the court, my name is Tom Lee. As my colleague, Mr. Bowen, has pointed out, I will discuss the relevance and impact of this court's decision in Roe v. Wade upon the present case. I think it would benefit us all to set certain things straight at the start. This is a prosecution for manslaughter, not for abortion. Dr. Marshall is not being prosecuted for performing an abortion. He is not being prosecuted for guessing wrong preoperatively that the fetus was non-viable when, in fact, it turned out that the fetus was viable. The doctor is being prosecuted for acts which were outside the scope of a legal abortion, which were in wanton and reckless disregard of human life, and which, in fact, resulted in the death of a human being. The jury in this case had to find that a fetus was viable in order for the state to assert its compelling interest in protecting the life of the fetus. That is what Roe v. Wade says. The doctor is not being prosecuted for having guessed wrong. Indeed, had the doctor determined before this operation that the fetus was non-viable, had it in fact turned out to be viable, had it in fact lived for a period of time and then died, there would be no prosecution for manslaughter in Massachusetts if everything that the doctor did in the course of that abortion was necessary to the termination of the woman's pregnancy and consistent with accepted medical practice.
Well, that sounds very good, but if I were a doctor, I'd be chilled. Wouldn't you?
Your Honor, a doctor, by the nature of his profession, is held to know what is accepted medical practice and what is not accepted medical practice. As this court determined in United States versus Vuj and later reaffirmed in Doe versus Bolton, there is no vagueness in holding a doctor criminally liable for acts which were not in the exercise of proper medical judgment. It should also be noted that this court's decision in Roe versus Wade only protects proper abortion procedure. That is, acts that are necessary to the termination of pregnancy and consistent with accepted medical practice. As this court said in its opinion at page 166, quote, "If an individual practitioner abuses the privilege of exercising proper medical judgment, the usual remedies, judicial and intra-professional, are available." The court there clearly reserved the right to the state to prohibit acts which were outside the scope of proper medical judgment. That is what the doctor is being prosecuted for here, and that is why he is criminally liable for manslaughter. Petitioner asserts that the prosecution in this case chills or burdens the constitutional right of a woman to seek and obtain an abortion. The short answer to Petitioner's argument is that this prosecution will only chill and indeed will only burden acts which are not necessary to the termination of a pregnancy and which are, in fact, inconsistent with generally accepted medical practice. As I have stated before, a doctor performing an abortion that is consistent with generally accepted medical practice need not fear any prosecution for manslaughter from the state of Massachusetts or from indeed any other state. It would be inconsistent with this court's holding in Roe versus Wade. The more general answer to Petitioner's burdening argument, and whether you characterize Petitioner's argument as a chilling argument or a burdening argument, I think that neither are appropriate to this case. The cases upon which Petitioner relies are cases in which the actual exercise of an individual's constitutional right was directly penalized or burdened by the state, as opposed to merely being deterred or threatened with potential prosecution if that individual did stray across the constitutional line. An example is the Simmons case, cited by Petitioner, where this court held that a state could not require an individual to waive one constitutional right in order to assert another. Another example is the Crandall versus Nevada case cited by Petitioner, in which the state of Nevada sought to impose a tax on people, either residents of the state seeking to leave the state or non-residents seeking to travel through the state who sought to exercise their fundamental right to travel. There is a difference between, as I have explained, between directly burdening and merely deterring. Any criminal statute which will hold an individual liable for his conduct necessarily will deter in some way conduct that is close to the line. But as Justice Holmes said in United States versus Wurzbach, the important question is not whether some conduct close to that line is deterred, but in fact whether the line is sufficiently clear. The standards to which the doctor, the defendant in this case, was being held, that of a generally accepted medical practice and wanton and reckless conduct, were sufficiently clear and granted him all the notice that the Constitution requires.
If the doctor in this case had held the fetus for 4 minutes, say a moment longer, so that the fetus was unable to take air into its lungs, would the doctor have been prosecuted for manslaughter?
The doctor could not have been prosecuted for manslaughter, Your Honor, because the essential elements of the crime of manslaughter, the fact that the fetus was alive, had been born alive, and the fact that it was viable, or just the mere fact that the fetus had not been born alive would prevent a prosecution for manslaughter.
So all the doctor had to do here was to hold his hand there for another moment. Is that it? That's the difference between being prosecuted for manslaughter and not, you're saying?
It's a difference between being prosecuted for manslaughter and not being prosecuted for manslaughter, but the doctor would not escape any sort of proscription by the state at all. As the quote from the Roe opinion that I read clearly indicates, the state would be free if it had some sort of criminal malpractice statutes, and I must confess that I'm not aware of whether Massachusetts does, but the acts the doctor performed would, even in Dr. Marshall's own admission, have been inconsistent with accepted medical standards. The state would be free to prosecute him for criminal malpractice.
Well, we're not talking about that. And if the state did that, there may be no problem. We hear of doctors being prosecuted all over the place for malpractice. Now you're talking about criminal malpractice. And you see how simple it is. You just add a word and it becomes a criminal case. And here you say wanton and reckless. And yet in response to Justice Motley's question, you say if the fetus had been held for 4 minutes, no prosecution because the fetus never drew a breath.
If the fetus did not live outside of the womb, then the essential element of the crime of manslaughter, that a human being was killed by the actions of another human being, would not exist. But the defendant in this case would not be able to get away with no sanction whatsoever.
Doesn't that seem like a bad principle to you? Isn't there something wrong with that?
Your Honor, the fact that the state of Massachusetts cannot prosecute the doctor for wanton and reckless acts which result in the death of the fetus, where the fetus did not live outside of the womb,
all right,
may be regrettable, but it should not deter or weigh on whether, when the fetus does live outside the womb, that it should be able to prosecute.
You have every element in this case, you say, and your proof on life depends upon that single breath. Isn't that true?
Yes.
That single breath that was taken.
Yes.
Is it not a fact that it is medically true that a child or a fetus draws breath in the uterus?
That is correct, Your Honor, but the
How
jury...
How do we know?
The jury was asked to find whether the fetus in this case...
How could the jury tell?
There was ample expert testimony. Several pathologists from both sides testified as to whether the fetus in this case had actually drawn a breath outside of the uterus or not. There was many pages of testimony to that effect. It must also be further emphasized...
Was there any evidence at all as to whether this might have been a dying gasp? No, I'm quite serious about that.
There was evidence to that effect, Your Honor. But the jury found, based on ample testimony in the record, that it was not a dying gasp, that it was in fact a breath.
Well, if this conviction is affirmed, wouldn't that affirmance come dangerously close to sabotaging the holding of this court in Roe against Wade?
No, it would not, Your Honor.
Because Massachusetts could, as this court noted, pass legislation regulating abortions.
Indeed, it has.
In most circumstances after viability of the fetus.
Indeed, in Massachusetts has. Subsequent to the prosecution in this case. However, Your Honor, as I have indicated...
Well, that won't help us very much, will it?
No, it will not. But as I have indicated, the woman in this case was perfectly free to seek and obtain an abortion. The doctor was perfectly free to perform that abortion in a proper medical manner. It should also be noted that at the time of this case, Massachusetts did not have any statute prohibiting abortion. Therefore, even if the fetus had been viable and the doctor had performed the abortion, that would have been a legal abortion if performed consistent with accepted medical practice. It should also be noted that this prosecution is not an attempt to regulate abortion, and when I use the word regulate, I'm using Petitioner's words, pursuant to the authority granted to the states in Roe versus Wade.
But don't you unduly burden it? And didn't we indicate that we will not stand for that kind of burden in the Bolton case?
Your Honor, as I have indicated, the burdening cases relied upon by Petitioner are cases in which the actual exercise of a protected activity was itself penalized. In this case, there is no direct penalty on the doctor or the mother for obtaining an abortion if that abortion is performed consistent with accepted medical practice.
What was the penalty in the Bolton case, in Doe against Bolton? That didn't involve a penalty. There was an over-regulation of the doctors who could perform the abortion and under what circumstances they could perform it.
In Doe against Bolton, the problem there was that the state sought to regulate abortion during periods of time which the Supreme Court in Roe versus Wade had declared that it could not. Here we're only here in the present case, which is why the element of viability is necessary to the prosecution in this case. Massachusetts, in order to assert its compelling state interest in the protection of human life, had to show that this fetus was in fact viable. It is not any more an attempt to regulate abortion than any prosecution for manslaughter regulates any activity in which the defendant was engaged in at the time that the homicide occurred. The state is merely asserting its compelling interest in protecting human life. The incidental impact of that assertion only goes so far as to require that abortions be performed in strict accordance with accepted medical practice. That is no more, indeed no less, than the state constitutionally can and does require of any medical operation, whether it be abortion or an appendectomy or whatever. Petitioner also seeks to argue that this court's decision in Roe versus Wade grants to the physician and to the mother an unqualified right to destroy the fetus. The language of Roe v. Wade explicitly protects only, quote, the woman's right to terminate her pregnancy. There is no right to destroy the fetus recognized either explicitly or implicitly anywhere in the opinion of Roe versus Wade. This court necessarily recognized that in the course of a legal abortion performed in strict accordance with generally accepted medical practice, the fetus would normally not survive as a necessary consequence of the premature termination of the pregnancy. However, the court did not grant either the doctor or the woman the right to perform gratuitous acts unrelated to the termination of the woman's pregnancy and indeed inconsistent with the health of the mother, inconsistent with generally accepted medical practice, when the sole purpose of those acts was to ensure the death of the fetus. Petitioner also seeks to assert the right to a dispositive preoperative determination of viability. Indeed, petitioner would carry that right so far that even after live birth had occurred, the fact that the doctor had determined beforehand that the fetus was non-viable would give that doctor the right to destroy that fetus.
But that would be true only if that judgment were a reasonable judgment in light of the medical evidence at that time.
Your Honor, we do not dispute the fact that prior to the abortion, the doctor must make a reasonable medical judgment as to whether the fetus is viable or non-viable.
And if he does that, would you say the state has no case?
Your Honor, that decision only goes to the question as to whether the abortion should be performed in the first place. I think it would be very unusual if such a determination should continue to be dispositive even in the face of clear evidence to the contrary, which is what petitioner argues for.
But if the doctor, in the exercise of reasonable care from a medical point of view, undertook this procedure on the assumption that the fetus was not viable.
Correct.
How do you get to the point of his owing even a duty not to be negligent with respect to a dead fetus or one that's not viable?
Your Honor, the fact that the doctor thought that the fetus was non-viable before the operation does not give the doctor the license to perform whatever acts he may wish to perform during the course of that abortion. The doctor is protected under Roe v. Wade only to the extent that his actions are part of a medically recognized and proper abortion procedure. The doctor
was the jury correctly instructed along the lines you are now arguing?
The jury was correctly and extensively instructed.
I rather read the jury instruction as allowing the jury, in a sense retroactively, on the basis of evidence put into the record by persons who had examined the fetus or the child after it had been expelled from the womb. In other words, they had the benefit of information the doctor did not have. The doctor wasn't so far off on the number of weeks involved. I think at one point he said he thought it was 20 weeks and then another 22. I think the court concluded 24. It's right on the borderline between generally accepted medical view as to what is a viable fetus.
Correct.
Now,
Carry on
from there.
Okay. The doctor in this case, as I said earlier, is not being prosecuted for having guessed wrong prior to the operation that the fetus was non-viable as opposed to viable.
Do you think he would have had the same standard of care, assuming he had exercised a prudent medical judgment to begin with?
Your Honor, if the fetus had been non-viable, the doctor would still have been held to the standard of only performing acts necessarily related to the termination of the pregnancy and consistent with accepted medical practice. The fact that he determined prior to the operation that the fetus was non-viable did not give him the license to perform totally gratuitous acts unrelated to the termination of the pregnancy, which in fact did result in the death of a live-born viable fetus. The jury in this case, as I indicated earlier, had to find that the fetus was viable in order for the state to assert its compelling interest in protecting the life of that fetus.
So, the jury had to find in this case, in order to convict, one, the doctor performed a wanton and reckless act.
Correct.
Two, that the fetus was viable.
Correct.
Three, that the fetus was in the process of being born.
Correct.
Four, that the process of being born is established by taking a breath.
The jury was instructed by the trial judge that the taking of a breath by the fetus was evidence that it had been born alive.
Now, what is there to change that standard or that test of being born or the taking of breath to indicate life? Supposing, in the next case, it is determined, because of medical advances, that they're going to take the brain wave of a fetus in the 8th or 9th month, and the brain waves will indicate whether or not the fetus is viable and alive. Even in the, let's go down to the first trimester, I can see that happening. Will that doctor who performs an abortion in a case of that kind with a viable fetus and has to do a hysterotomy be subject to a manslaughter prosecution?
Your Honor, I'm not sure what you're driving at, but let me try. I'm
driving at the fact that the standards for life can change.
Yes, indeed they can.
They may be other than taking a breath.
As the standards for viability themselves can change.
That is right. And therefore, isn't it better to define this by statute?
Your Honor, your argument seems...
Rather than case by case.
Your arguments seem to go to my colleague Mr. Bowen's arguments about retroactivity and vagueness. And there may indeed be some merit in the state defining those standards by statute. But this court has, on many occasions, recognized the validity of common law crimes and the essential nature...
I've heard that, and there's no need to repeat that.
Petitioner seeks to rest this unqualified right to destroy the fetus on the mere inconvenience that the mother may undergo in bearing and caring for an unwanted child. While the Commonwealth acknowledges that this court itself said that that consideration was a valid consideration in the woman's original decision to seek and obtain an abortion, the court nowhere says that the convenience of the mother can be extrapolated to grant the doctor or the mother the license to commit any acts, however unrelated they may be to proper abortion procedure, however inconsistent with accepted medical practice, solely to ensure the death of the fetus. In conclusion, I would like to say that a woman has the right to seek and obtain the termination of her pregnancy. That right is protected by this court's decision in Roe v. Wade. The doctor has the right to perform an abortion, any abortion, as long as that abortion is consistent with accepted medical practice. That right of the doctor or the doctor's actions in that case are also protected by Roe v. Wade. If the fetus, as a natural and necessary result of the performance of that abortion, when that abortion is performed in strict accordance with accepted medical standards, is born alive and then dies, that is not manslaughter. However, the doctor is nowhere granted the right to go outside of that context, to go outside of the context of illegal abortion to ensure the destruction of the fetus. If the fetus that he goes outside of the context of illegal abortion to destroy is later born alive and dies, the state can, under Roe v. Wade, constitutionally prosecute for manslaughter.
Let me ask you, supposing the mother destroyed a viable fetus during the process of aborting herself, that's been known to happen.
Yes. If the fetus were found to have been viable and born alive, the state could prosecute the mother for manslaughter.
Do you know of any such prosecution?
There have been, I think, prosecutions in other states, and I cannot with any assurance tell the court whether those were prosecutions under abortion statutes or under manslaughter laws, but there have been prosecutions of women who have undertaken to abort themselves.
What did the Massachusetts abortion statutes provide which were voided by Roe?
Which were voided by Roe?
Yes.
As I understand them, the Massachusetts statutes prohibited all abortions except when necessary for to preserve the life and health of the mother.
Were prosecutions brought under that statute at any time, or were they always brought either on the murder, or I guess you didn't have any manslaughter convictions. Did you have any convictions at all in Massachusetts?
For prosecution on the abortion statute? Yes, there were. While it was enforced prior to Roe v. Wade, there were many prosecutions on the abortion statute for abortions that were performed both by physicians and by, I'm fairly sure, by mothers seeking to abort themselves. In short, there is nothing in Roe v. Wade or any other case in all of American constitutional jurisprudence that confers upon the doctor or the mother the independent right, that is, outside of the context of illegal abortion, to determine whether or not an independent being must die. Respondent merely asks that this court affirm the Commonwealth's attempt on this occasion to protect the sanctity of human life, an interest that the Commonwealth is compelled to assert as much on behalf of the infant son of Alice Roe as on behalf of the defendant himself if he were in similar circumstances. I thank the court for its time and attention.
Let me ask you one question before
Yes, Your
you
Honor.
sit down. You still have some time, I see. Do you agree that the burden here, let us not call it a burdening the vindication of women's rights under Roe, but the burdening here will fall in the main upon the poor and the young and the mentally disturbed young women, because they will be the individuals who will wait until the end of the second trimester or the beginning of the third.
Your Honor.
Others will go during their first trimester.
Your Honor, the problem there is that it seems that you're talking about a statute prohibiting abortions. That is not what this case is about. Under the law as it existed at the time of this prosecution, an abortion...
I'm not talking about that at all, Mr. Lee. I'm talking about a prosecution of manslaughter because the fetus is viable. And I'm saying that you have a viable fetus only in those instances where these women wait too long. And doesn't that usually occur in those cases?
Your Honor, there would only, as I said, there would only be a burden if the doctor departed from proper medical procedure in the performance of an abortion.
Why? If a doctor used the finest procedure, but it wasn't for the benefit of the mother's health, what would you say?
If the doctor performed an abortion consistent with the finest medical procedure, then that would be protected under Roe v. Wade, and the state could not prosecute for manslaughter. And there would be no burden on anyone, be they poor or mentally disturbed or not.
Well, I read Roe against Wade as saying that in that trimester where the fetus is viable, the state may enact statutes. They may either prevent an abortion entirely or prevent statutes. They may enact statutes that only permit an abortion for the purpose of saving the mother's life or health.
That is correct, Your Honor. At the time of this prosecution, the state had not chosen yet to exercise those rights. Therefore, an abortion performed after viability, as long as performed in a proper and generally accepted medical procedure, was perfectly legal.
How do your statutes change that? I'm talking about Section 12L and 12M of new abortion laws.
Of the present Massachusetts abortion law? The present Massachusetts abortion law does prohibit abortions after viability. That statute may indeed place an unreasonable or unconstitutional burden upon women who, for whatever reason, may be seeking late-term abortions. But, Your Honor, I must insist that that is not this case, that this is a case for prosecution for manslaughter and not for abortion.
So you're telling us to look out for the new Commonwealth statute when it reaches our court.
That's exact. With all due respect to the court, what I'm saying is that when the Massachusetts abortion statute comes before this court, if it does, that is the proper time to decide whether that statute unconstitutionally burdens the women's rights.
And isn't it the lack of a Massachusetts statute which gives all the problem here now with respect to securing the rights under Roe? Isn't it the lack of a Massachusetts statute which is giving us all the trouble here now in this case, because there wasn't a statute at that time?
Your Honor, there was no statute, but I think that the law was sufficiently clear that Petitioner should very well have known. In fact, he in the transcript admits that his acts were not justified by any proper abortion procedure and would be detrimental to the health of the mother, would terminate the life of the fetus. And the fact that Massachusetts, after Roe, had not yet chosen to prohibit abortion should not restrict the state from asserting its rights properly under the common law of manslaughter.
May I have a last question also?
As long as I have time left, exactly.
I think you have some time. I want to return to the question that Judge Motley put to you earlier as to the effect here in Massachusetts of the recent decision in Monet against Greyhound Lines. That was a tort action.
Yes.
The Massachusetts court held that a viable fetus is a person.
Yes.
Regardless of whether it's been born or not.
Yes.
Now, assuming the present status continues of no abortion statute and no definition of manslaughter,
yes,
what, if anything, is to keep the state from bringing a prosecution against a doctor for manslaughter predicated on Monet, which says that a viable fetus is a person, that being contrary, mind you,
yes,
to most of the jurisprudence in the United States?
Exactly.
Where does that leave you here in Massachusetts?
As Your Honor pointed out, the case of Monet versus Greyhound bus lines was a civil action. There is not a strict equality between the definitions of life and in the civil context as there is in the criminal context. Petitioner sought in his brief to argue extensively that the Commonwealth of Massachusetts could not rely upon that case as authority within Massachusetts for the fact that the fetus in this case was born alive. The Commonwealth has not sought to rely on that case. It was not cited at all in the Commonwealth's brief. And as to whether the Commonwealth could in the future apply that definition in the criminal context, I think that would raise some new and interesting constitutional questions.
I promised to ask you only one more, but you've suggested another. When you get out into the practice of law, let's assume your first client is a young doctor, and he consults you with respect to whether or not it's prudent or safe for him to perform an abortion in light of Monet. Fetus, let's say 24, 25, 26 weeks old, clearly viable.
Mm-hmm.
Do you think you could tell him he could do so with no risk of being prosecuted for manslaughter?
Is this in the absence of an abortion statute?
Yes.
I would tell that doctor that there was certainly the possibility of prosecution under the manslaughter law. But as I said before, the state has not asserted that definition in this case. And therefore, I don't think that this particular prosecution for manslaughter, has whatever constitutional or otherwise defects may exist in that case.
As a lawyer, you tell him there's a possibility of his being prosecuted. As a friend, you tell him not to do it.
I would certainly tell him not to do it. Thank you.
Mr. Lampert, I think you have, 5 or 6 minutes?
I think, unless the time I have left over counts.
Well,
I hope to be brief in any event.
we'll find out.
May it please the court, and whatever time I do have, albeit brief, it would obviously be foolish for me to attempt to answer all of the points that have been raised in discussion tonight, even presuming I could do so. In any event, I should like to talk about 4 things. On 2 matters, I should like to call the court's attention to our brief, which I think adequately answers the problems raised here tonight, and I'd like to spend a little more time on 2 other matters. The 2 matters that I would call the court's attention to parts of our brief are on whether a departure from silence can constitute retroactivity or not. I would refer this court to the decision of an inferior court, the Fifth Circuit, in United States against INSCO, which is in our brief at page 16 and our reply brief at page 5. They seem to indicate a departure from silence does violate Buoy. Additionally, as to the distinction between a burden and chill and whether there can be chill where there is no overbreath, we would refer this court to our discussion in the main brief at page 32 and the reply brief at page 8. In the reply brief, as you may remember, we spend a lot of time talking about Spicer, Smith, Simmons, and New York Times against Sullivan, which we think adequately demonstrate that there can be chill even where there is no overbreath. Having referred the court briefly to those 2 matters, I'd like to focus in on 2 other matters. In this case, because of the highly technical nature of the medical evidence, and because of this court's decision in Roe against Wade, and because the medical profession prefers not as good medical practice to do illegal acts, we have a complicated set of interactions between the law and medicine. There was testimony at trial about textbooks which said that abortion was any procedure before the 20th week. All of the experts agreed that the textbooks had adopted that definition because that was the then prevailing view of the law. There was not a medical reason to limit abortion to 20 weeks. We suggest that this interaction between what the law allows and what is good medical practice makes the use of a good medical practice standard in this case all the more objectionable to the extent that it provides the jury additional discretion. We suggest that the medical practice is reflective of the law, is reflective of the medical practice, and that is bound to confuse the jury and bound to lead to differing expert opinions, and that situation leads to confusion, and that is among the reasons why this court should overturn the conviction below for vagueness. The only other point I should like to make in closing is to focus in on a point that I think Justice Kaufman has identified, at least I hope he's identified. I think that it is important here to remember that the Commonwealth has repeatedly told us that this is a case of manslaughter, not abortion. The reason it is a case of manslaughter and not a case of abortion is because of the absence of an abortion statute. The lack of authority, which Justice Kaufman has repeatedly talked about, is, I think, because of the lack of the prior existence of an abortion statute. We suggest that that analysis precisely illustrates the nature in which, or the way in which, the Commonwealth in this case has extended the manslaughter law to cover acts that it was never conceived to cover. With that conclusion, I would like to thank the Court very much for its attention and yield back the balance of my time.
The Court will take a recess and go into a conference, and we'll come back, we hope, in a reasonable period of time. We were informed that our duty was to make 3 judgments. We were to decide the best brief, the single best oral presentation, and finally we were to make a judgment as to the winning side. I hardly need say that we have no responsibility to judge the merits of this case. I speak for the Court in announcing first that we considered the respondent's brief to be the best brief. We considered Mr. Bowen's argument to be the best oral presentation, and we judged the respondent's to be the winner. I would like to make a very few remarks, certainly not a speech, and then I'll call on my colleagues to say anything they care to say. I'm not very experienced at this moot court business, but I would say that based on experience sitting at the Supreme Court for the past 4 years, this is one of the most difficult and complex cases with more subtle issues in it that I've seen. Yet the judgments we've made were rendered all the more difficult by the excellence of the briefs, and they were excellent, and the excellence of the oral arguments by all 4 of the participants. It seemed to me that you were extraordinarily good, all 4 of you, at responding to questions, some of which I would have hated to have to respond to myself. I think I can sum up the way I feel by saying that my life at the court would be more stimulating, and I'd be somewhat proud of our profession if everyone who performed there did it with the skill and grace and poise and effectiveness of the 4 young gentlemen who've argued this case here this evening. It's been a great privilege to sit here. Judge Motley?
Well, I'd just like to say that I think it is unfair to ask us to come here and decide this case, because it's really unreal. We never get briefs this well prepared. or lawyers this expert at replying to questions put to them by the court. I found it extremely difficult myself to make the decision, but as we always say, somebody has to win, somebody has to lose, and so we had to finally make the decision among men that I found to be excellent in all respects. In addition to the remarks already made by Mr. Justice Powell, indicating to you that our first preference with respect to the argument was Mr. Bowen, I'd like to commend Mr. Lampert for his rebuttal. I thought that was very, very good. I wasn't joking when I said initially that I had to reread Buoy to recall that case. I hadn't realized myself it was 11 years ago. And I think one of the reasons I didn't recall it was because at the time we argued about 4 or 5 cases at the same time, and the arguments were divided between us and was kind of confusing. But it certainly gave me an opportunity to recall my days in the Supreme Court and to remember how nervous I was before the High Court. And so I know how each of you gentlemen must have felt as you stood here tonight and tried to field these very difficult questions that we put to you. And now that it's all over, I can confess that my 2 Harvard law clerks helped me to figure out those tough questions for you.
Chief Judge Kaufman.
Thank you, Justice Powell. You know, applause in a courtroom is a strange sound to me. I had heard a story some time back, and I never thought I'd witness this. You all remember Judge Rosamond, who was counsel to President Truman and to President Roosevelt. He went back to practice in New York, and he told a story about having been before the Supreme Court to argue the Gibson case. And he started late one afternoon. Earl Warren was the Chief Justice, and he went over to the next morning. And his law clerk picked him up on the way down. He said, Judge Rosamond, he said, you know, I had a dream last night about this case, and I wonder if I could tell you about it. He said, sure, go right ahead. He said, well, my dream was that you didn't show up at the court today. And the Chief Justice leaned over and said, where's Judge Rosamond? And I said, well, I had breakfast with him this morning. He should have been here. I don't understand it. He said, well, you're on the brief, aren't you? He said, yes, you know all about the case, don't you? He said, yes. He said, well, go ahead, you argue the case, you finish it. So he said, I went ahead and I argued that case. He said, and my dream was concluded this way. He said, as I finished my argument, it was so brilliant that all 9 justices stood up and applauded me. Well, we appreciate your applauding the justices here today. In these moot court competitions, one side wins and the other side loses, but I must say the difference is usually hair's breadth. It is very close, and it is very difficult to decide these things. So difficult that I often wonder whether there wouldn't be some way of settling these cases before we hear them. And you know, we have a colleague, at least Judge Motley does, on the district court, who's one of the great settlers. And I must say, the story is apocryphal, and I concocted it, but I had to introduce him once at a luncheon, and I said he was a man who disposed of a great deal of business. I said, as a matter of fact, last week he went up to Yale to judge a moot court, and he told his wife he wouldn't be home that evening because the moot court would end quite late. And about 8:30, and he walked into his apartment. His wife said, what happened? Said, I thought you were going to stay there overnight. He said, oh, well. He said, I heard the kid for the plaintiff open, then I heard the kid for the defendant open. I called him to the bench and I settled the case. On a more serious note, I would say that I would be perfectly satisfied if the level of advocacy in the Second Circuit approached the performance demonstrated here. I've thought about that, and I suppose there is a solution to it. We could change the name of our court to the Ames Circuit, and we could have only Harvard men appear before us. But that would create some difficulties because, you know, Yale is in our circuit. And President Ford is a Yale man, and he's still funding our court in New York City. So we'll leave that alone. All I want to say really to the four of you is that, and your teammates, that I commend you. Advocacy is your craft. Stay with it. We expect to hear great things from you.
I may just add this, in light of what's been said, if this warm audience continues to applaud, we might stay here quite a while.